Okay. Yeah. Miguel is online, so I asking him now. So see if he could come on in 10 minutes and explain, which would be good.
Okay, thank you kindly.
Okay, all right. That's fine. That's fine. So let's do a, hold on. Did I print the question? No, but I have an idea what it is in my head. So what's your approach to the question? How are you going to approach it?
I guess for me, I would want to start off with the research. Once I've completed my research, then I would be able to start, putting it together as to what is what.
Okay, all right then. So you haven't started the research as yet?
No, not as yet.
Okay, all right, right. Yeah, I figured it was a little bit too early. That's why I didn't mention the paper at the first class, because I said most people probably haven't started their research yet. So, okay, I give you all time. I give you time. So
that's correct, method. Good morning all. Sorry, good morning all. It's more of a research paper than anything, you know what I mean?
Mm-hmm.
Yeah, so
all they have to do is answer the question, add footnotes, bibliography, make sure you word count, and that's it.
Correct.
So they just email it?
Well, actually, no, they're going to get a link. They're going to get a student number and then a link, because I don't know if I have the deadline yet, and then they have to upload it. They'll get a link to upload it with their student number.
Oh, okay.
Okay. So they'll get some instructions. Once they finish it, they'll save it in the PDF document, and then they'll upload it. They have a link where they upload it. So and then it'll be marked by charter banker, and then that grade will be added. That grade will be added to their final exam. And then, so when they take their final exam, they'll know if they pass or whatever their score is.
Mm-hmm. Okay.
Okay.
Any more questions, Candace?
No. Everybody feel free to call me. Everybody have my cell number. They can call me.
Yes, thank you.
Okay. All right. Trinique, no questions from you, right?
Morning, no, Mom. I'm good. Thanks.
Okay. All right. She's good. Okay. Thanks, Miguel.
All right.
Okay. Again, morning to those who are just joining. I know you all must have been very busy watching the coronation of the future king. That's why you all sound so sleepy and tired. No? Why everybody going so quiet?
Yes, Natasha, I was watching it up early this morning.
I figured that. How far are they? When I looked earlier this morning, which was about before 8, I think the choir was singing. I said, too much singing, I got work to do. So how far are they now?
I don't know, because I had to go out. So I just left it.
You know,
I'll catch up later.
Huh? Say it again?
No, I said I'll catch up with it later.
Yeah. Yeah. Other countries have Monday as a holiday. So, I mean, if you had to work or like how we have classes on Monday, you could sit down and then watch the whole thing. Because by then, you know, BBC would have everything together for 2 or 3 hours or whatever it is. But we don't have a holiday. So I don't know when I'll watch it. I'll just see the clippings. All right, so let's get started, because I know time is of the essence. So last class, we looked at the Bahamian legal system. So you all are now aware where laws come from, why we have laws in place. You know how the judicial system works, going from the administrative courts to magistrate court, Supreme Court, Court of Appeal, and then to the Privy Council. We also discussed legal consideration in terms of if someone came to you or you wanted to advise someone at a type of business structure that they should have, taking in consideration that when you talk about establishing business, you must think about liability, and liability is key. So it's whether or not they're going to do a sole proprietorship, which is a trading as, or they're going to form a partnership, and normally that's left for professionals. And then they can form an actual company. And a company can be formed under the Companies Act or under the International Business Companies Act. And we also spoke about briefly the process in order to get your business license. That's on the website of the Department of Inland Revenue. And it actually is a very good website because it gives you the step-by-step process of what is required. After that, we looked at what if there is a visitor to the Bahamas who wants to see what type of residency that he can obtain in the Bahamas to stay for whatever purpose. So we spoke about residency. We spoke about work permit. We also spoke about those who could spend $750,000 to purchase a home, which gives them a speedier way in order to get their permit to actually live in the Bahamas. So now let's look at what are the fundamentals of purchasing property. So we know that property is one of the most important investments that a person can make in their lifetime. And so if you were going to advise someone, again, remember now with this CIFP, you're advising people in different age group. So I'll start with Trinique. Trinique, if you were advising a young person now who just started working, so say they finished the college and they're going into UB now, or they're going straight into UB, or they just finished UB. So say they're between the ages of 21 and 25. What would be your advice to them in terms of property? Either they're just starting to work and have saved up a few dollars, or a relative has died and left them some money. Okay. Or the person died and left them property. Well, how would you advise them?
Okay, with it being the person who had started working and was working towards saving, or had started saving towards purchasing the property, I'd advise them on seeking out their options to see what they would be eligible for. So they'll know the requirements needed and have like a financial goal set towards the first steps of obtaining the property. And then with the one who would have had the property passed down to them, make sure the legalities of that property ownership is sorted out. They have a clear understanding, and then guide them in the direction as to what next they'll be able to do and secure the land for them to use, and have no rifts with anything else or any other family members involved.
Okay. Major, what if the person's about 35, 40? What advice would you give?
If they are 35 or 40, I would just advise them making sure that everything is there. If they have the monies to look into possibly looking for distressed properties, or distressed locations and probably just looking into renovating and possibly using it as rental income. I wouldn't 35 to 40. I'm guessing also it could be a good time to look to build, your own property, but also I would say first concentrate on trying to get something that can generate income for them first. And then look into expanding and getting their own home and property if they don't already have it.
And Candace, what if the person is 55, 60, going in that pre-retirement age range? What's your advice?
A pleasant good morning to all. I guess looking at that age range, I'll have a conversation with the client. In my mind, I'm thinking that they want to purchase it and they're probably looking to generate some revenue from it. So I guess that's the type of discussion we'll have based on the assessment. Because of their age range, I would probably try to see how best I could guide them not to go into something so long-term that would cost them so much of a debt. See how quickly we could turn it over and to get it started to generate some income for them.
Yeah. So notice that in everything that you're going to do with this certification is all about trying to guide individuals in terms of creating wealth or minimizing losses. So when you look at purchasing property, and you could hear a lot of horror stories about property. I could tell you many things about property. People building on the wrong property, people selling property that's not theirs, selling it over to like 7 different people over and over again, making profit, then come to find out you build a house on it and the person who sold it to you doesn't own that land. And then the actual owner bulldozes it down. So we have a lot of issues when it comes to property. So the first thing when you try, if someone comes to you now and they say they're interested in buying a piece of property anywhere, the first thing is they have to get a contract between the seller and the buyer. And in that agreement, it normally should tell you the actual property, where it is, because it should have a plan at the back. It should tell you the purchase price, the deposit, how much time do you have in order to complete this whole transaction? What is the obligation on the seller? And what are the undertakings by the attorneys on both sides, the seller and the purchaser? And then what happens if the seller cannot deliver his obligations? And his obligation is what we call in the law of property, good and marketable title. And that good and marketable title is the key to when you are purchasing property or if you are selling property. A lot of the matters that go before the court has to do with whether or not the person had good and marketable title. So the deposit is usually 10%, and that is paid to the vendor's attorney once you sign the contract. And those funds are held in escrow. So after they've signed the agreement for sale and you get the documents with the vendor's title, then the purchaser's attorney will then start to investigate the title. So in the past, and you may still even have it in the present, a lot of issues came up with attorneys who are actually investigating the title. That is doing the title search to see who owns the property. The first place to look at is the Supreme Court cause list to see if there's any pending judgments before the court related to that piece of property. Again, persons have purchased properties that were on the court's list. Sometimes the court had 3 matters before it on that same piece of property. So under the Act, a purchaser of land is not entitled to require title to be deduced for a period of more than 30 years, or it has to go back to a grant or a lease by the Crown, by the government, or the court may have granted a certificate under the provisions of the Quieting Titles Act. And so if you read the newspaper, you'll see those ads, and you'll see the ad at the very top, it says quieting title. So out of those 3, whichever one is shorter, that's where the attorney will actually stop their investigation. So once a purchaser's attorney has done all of those research, they can raise questions to the vendor. And those questions will be trying to cure any defects that they would have seen in the title, because the title tells the story and there shouldn't be any gaps in the title. If there are gaps, then the purchaser's attorney is going to ask the vendor's attorney to address those gaps. So the time for putting in these requisitions is 14 days after the purchaser's attorney received those title documents. Now, the purchaser's attorney can also raise questions on whether requisite government approvals have been given, subdivision approvals, whether there's any outstanding taxes, whether surveys were done, if there's any rights of way on the property, whether there's any easement on the property, and whether there are any restrictive covenants on the property. All those questions can be raised. So once the purchaser's attorney is satisfied that all of their questions are being answered, they will prepare a report on the opinion of title. And if the person is obtaining a mortgage, that report is sent to that financial institution. The draft conveyance of the property is prepared by the vendor's attorney, and it will be reviewed by the purchaser's attorney. So the conveyance would include the name and addresses of the parties, any references to earlier title documents, description of the property, if there are any restrictive covenants. And restrictive covenants means that the original owner of the land may have stated in the document that this property is not to be used for this purpose. Or there can be an easement, which means that persons can move on another person's property in order to access certain facilities, or there can be rights of way, which means that you have the authority to pass through someone's property in order to get to your property. And then you could have the plan of the property. If it's a foreigner, any affidavits of citizenship, and of course, it has to be witnessed. So once the conveyance is finalized by the vendor's attorney and is executed by the purchaser and the vendor, the signatures are witnessed. A completion statement is then prepared by the vendor's attorney, and the balance of the purchase price is paid to the purchaser's attorney. And of course, that's less any of government fees. The legal fees normally is between 1.5% and 2.5%, and that's paid on completion by the seller and the purchaser to their individual attorneys. The commission to real estate agents are also paid at this time, and requests are made to the utility companies to return deposits to the vendor and all utilities. And then the real property tax assessments are placed in the purchaser's name.
Excuse me, Ms. Archer, can I ask a question, please?
Yes, go ahead.
I just want to go back to the part that you were talking about with the 30 years. If you purchase a property. Can you just clarify that for me, please? Because
Okay.
if I'm understanding, oh, go ahead.
Okay. So let's say you're purchasing a piece of property from, I don't know, B. A is purchasing from B. Now, you sign a contract to say you're going to purchase this property and you give your deposit. B has to provide to A's attorney the documents proving that they are the owner of that property. So most likely they would send their conveyance or a copy of it so that the purchase attorney can read it. Now, because we have unregistered land, that means that you have to conduct a research to make sure that that conveyance that the vendor has given to you, that they have proper title to that land. So in the law of property, it's called having good and marketable title. You have to prove that. To prove that, you have to deduce title. And to deduce title means that there are 3 different criteria for you to prove good and marketable title. One is that you have to take that conveyance and you have to go back 30 years. So let's say the conveyance said that it was sold to B on the 1st of March, 2021. The purchase attorney need to now go to see who had it before the vendor in 2021. So let's say he finds C. C had it for 2 years. So let's say that was 2019 to 2021. He has to keep going for 30 years. When he hits 30 years, then he can stop. But if while he's doing that research to see who were all the previous owners, he sees that one of those owners obtained that property by a lease from the Bahamas government, and let's say that happened 12 years ago, his research stops there. He doesn't have to go 30 years because he now has a grant or a lease by the Crown. And in the same instance, if the person started from today, goes back, individual C, D, E, F, and then it sees that G obtained the title to that property by acquiring title action in the court, it stops there. It doesn't have to go 30 years. That's what that timing means.
Okay, I have a good understanding of that now then.
Okay.
But let me just put a twist on it. Let's say you're doing the research, and let's say that, I didn't hear you use the letter E. Let's say in the middle of there, E purchased the property from D, but what happened? E never got that property recorded. In a case like that, what would happen, let's say, if they sold that property, like how you say a lot of properties got sold, how the mere fact that E purchased it but never got it recorded, would they have some grounds, legal grounds?
It has to be recorded. That's the process in unregistered land. So whoever recorded it first is the owner. The law says first in time.
Oh, wow.
But when you go before the court, maybe what you should, it really gets tricky because the court is going to go through each title from both sides to see who is actually the legal owner.
Scary. Thank you very much.
No, it ain't scary. It's a reality. It's a reality. It is it's a lot of matters go before the court on property because we don't have registered land. So if I were to sell a piece of property now, right, to you and to Paula, both of you the same time. So both of you pay me. Whichever one of y'all get there first is the owner of that land. You have to register it. That's the key to that. So even after this certification, if you have someone who has a piece of property who wants to sell, you can, if anyone within this group is a real estate agent or you know of one, you can be the financial advisor, whereby the real estate agent, you take them to see the property on behalf of your client. You check to see what are the proposed valuations of the property, so you'll get it appraised. And then you, on behalf, after speaking to your client, are able to advise them whether or not they should sell it, what range should they hold for a time period, look at the terms and conditions, and make sure that they have good and marketable title. If on the flip side, your client wants to purchase property, again, make sure that the vendor has good and marketable title. And always remember, and processes change over time, because you know how government work. Government don't publicize everything. Things you hear, and then some things are written. They try to do nowadays, because everything is computerized, by putting everything online. But you have to make sure when you're advising that you follow every step that is required, especially when it comes to land. Any comments? Questions?
Good morning, everyone. Ms. Archer, I have a question.
Okay.
When it comes to the conveyance, it says, one second. The conveyance must include the names, addresses, etc. And you said any restrictive covenants, right? If the person say, for example, no commercial building is to be built on the property, is that like a restrictive covenant?
Yeah.
Oh, so even if you buy, you can build a commercial property on it?
No.
Oh, okay.
And those are the things that the lawyer has to look for. The key things, because you don't want to buy a piece of property. Like sometimes they could put inside the in the conveyance that this property cannot be used to sell liquor.
And the person who puts this restrictive covenant on it will be the seller.
No, that would the restrictive covenant runs with the land.
Oh.
So first person that got that land, they put that in there.
Oh, okay. And it can be changed.
In some instances, the government can rezone an area.
Okay.
Yeah. But these are the things that you're looking for as an attorney when you're looking and deducing title. You're looking to see whether anybody has permission to walk through your property, to go to a property in the back. Whether or not the person has permission or has a right to come on your property and use the water from your well. All those things are in that original conveyance, and they have to continue. So that's why you see when you're purchasing a property, and some people say the lawyer takes so long because he has to check all of that. All of those things have to be checked. And as the property moves from hand to hand to hand, you have to check and see if they were recorded. So they're going to have to confirm the page number and the volume where they were registered.
I have another question, Ms. Archer.
Go ahead.
Is there a reason why we're not working on having a proper land registry?
My lips are sealed. Why you think?
Okay.
Think about it. No, think about it.
I guess it'll awaken a lot of corruption. I know. I don't know.
Corruption is already awakened. That's what happens in the court.
Okay.
That's what happens in the court. When someone comes and says, this is my property, you built on my property, in the court, after the court does the whole deduction of title, then the court declares who owns the property, and then the owners then bulldoze your house that you took all the way to Belcost. You've lost all of that money. Now we have cases that went to court where a person, let's say they're living on a piece of land, I don't know, let's just give a number, 200 by 400. They're surrounded by bush. And so what they do is, or what this person did was, because it's surrounded by bush, you can't see what they do. So behind their home in the bush, they added on, built something else, and then they started to extend their fence year after year after year after year after year, taking it further and further out. And then when persons who, I guess, according to them, owned some of that land, came to check on the land, and they went in the bushes, and then they found out that this person who's living in the back had extended their property all the way into their property and built structures on it. And then that person claimed that they own all of that land, and they brought their papers out. And then the person who came to check on the land brought their papers up. So this was the case in court where three different parties brought their papers out, all claiming to own the same land. And the court had to go through each one title. Now the gentleman who was building on the property and extending his fence, the court stopped that. Only what he was entitled to legally on the conveyances that were drawn up by his parent. The other one, the claim had to do with, partly was on conveyance and partly was on hearsay. So they lost some of the land that they wanted. And then the third one was awarded quite a bit of land because they actually had good title to that land.
So the pieces that he already built the homes on, he had to destroy?
The owner would destroy it, yes.
Okay.
Mm-hmm. So when you talk about conveyance, who's the key player in conveyances? What's the key player?
The lawyers?
Okay, so that answers your question.
Okay.
You're thinking, if I see you read half and thing out. So if the land is registered and I was selling a piece of property to you, all you have to do is go to the system, and then the all of the history would come up.
Miss Archer, I have a question. Where does title insurance fit in with this whole situation? Who is it protecting?
Yeah, they're the ones that do the research.
Okay.
Yeah.
Okay.
So if you get like foreigners would get like Americans, they like to get title insurance. And the title insurance means that if there is a default, then I'm covered because I have coverage. Because that's the risk that you have when you're dealing with unregistered land. Things just come up. So that's purchasing property. Now the next section is, what if that person wants a mortgage? So if the person wants a mortgage, I would recommend before you say, yes, let's go to the mortgage route, it would be good if you could have in your back pocket a comparison between rental and mortgages. Because you know, there's some people like to rent and they will never buy a home. So what are the advantages and the disadvantages between renting and having a mortgage? So the first thing you have to explain is, what is a mortgage? So a mortgage is where the bank, as the mortgagee, it takes an interest in your property. And that interest in the property is the security that the bank takes until you have completed the payment of your debt in full. So there are 3 different types of security over land or real property. The most common one is the one that all of the banks offer and the one that they advertise every week, a legal mortgage. And that means that the legal interest on the bank is affected in the mortgage. Now, in order for this to happen, the person who is coming to the bank for a mortgage must own that property in fee simple, absolute, in possession, which means that there are no other liens against that property. Or they can have a lease on that property. So by having the property in fee simple, absolute, in possession, it means that you own both interest in that property. Remember, nobody owns land. The Crown owns the land. When you purchase property, you purchase an interest in that property. And that interest is twofold. You have a legal interest and you have an equitable interest. When you obtain a mortgage, that legal interest goes to the bank. You retain your equitable interest. Everybody understood that?
No, can you go back over that, please?
Okay, all right. So, you've purchased a piece of property. You just went through purchasing a piece of property. So you have the property now. You've paid for it. You have to pay it in full in order to have fee simple absolute in possession. So fee simple absolute in possession means that you have the title documents to this land Nobody else owns this land. There are no claim against this land. You own it outright. That's what that means. So you decide now that you don't want to rent anymore, or you're living with your parents, you want your own home. So you go to the bank to apply for a mortgage. A mortgage means that you're going to transfer your legal interest in that property to the bank. The bank is going to take that legal interest and it's going to form itself as a security until you pay off your debt. So the bank now, how it makes its money with mortgages is there are three types of security that they could obtain from the borrower. The first one is the one I just spoke about. If you have a property, you own it outright, there are no liens against it, there are no loans against it, you can enter into a legal mortgage with the bank. So that's when you take your conveyance to the bank and you say, I want to build on this property, or I've gone up the bill cost, I want to finish it. The bank then takes that conveyance. Again, you're going to have to do that whole title search again. Because the bank now has to make sure that when it takes over the legal interest in that property, that you have good and marketable title. So that legal interest, because you have fee simple absolute in possession, you owe no one on that property. The bank will then, once you meet the criteria, they will take that legal interest in the property as a form of security. And then I said that that legal interest they take, they leave you as the borrower with the equitable interest in that property. To break it down even further, be mindful that all the land belongs to the crown, to the government. When you purchase a property, you purchase interest. You do not own that land. That's why the government has the right, when it's building a road, to come and tell you, we're building a road through your property. This is the value, market value of your property. This is what we're giving you. And then you have to find someplace else to live. You purchase interest in the land. So with a mortgage, the legal interest goes to the bank and you keep the equitable interest. And this can also be done with a lease. Everybody understand how a lease works?
Yes, for the most part.
Okay. So no more questions on that. Clear it in mud?
Yes, ma'am. So,
Sure.
so you're saying, okay.
Go ahead.
Right now, like everybody who owns property right now, they only have an equitable interest in the property.
They have both if they don't have a mortgage.
They don't have a mortgage.
Mm-hmm. Or a loan against that property.
Okay. And the government can do whenever they want, like how they destroying some of the buildings downtown. That's why they could do that.
Mm-hmm.
Okay. Thank you, Ms. Archer.
Mm-hmm.
Okay, Ms. Archer, so a question in a situation where with, let's say, with foreclosed homes, the previous mortgage owner, they obviously only had the equitable interest in the land. They couldn't live up to their requirements to pay their mortgage. So now here comes a new person trying to obtain this home that's on the land that is legally in the interest of the bank. Now go about purchasing a mortgage for this property or the home on this property. When all the fine trimmings are done, at the end of the day, the bank still has the interest on that land, but you have the equitable interest, which is the building, the home that's on it. Or how?
Okay, so, all right. So you have a mortgage and you've missed payments. The bank has tried to work with you. Bank then decided they're going to go for vacant possession. And then from there, they're going to decide that they're going to sell the house. So once they put the house on the market, after they've gone through the homeowners protection sections, which means to find out whether there's anybody else in the home who could take over the mortgage and all of that. So once they've exhausted all of that and they say, okay, they can't pay for it, it's up for sale. So let's just say you want to buy the home. The first thing is they look at what is the appraised value, and the appraised value is what they're going to sell it to you for. Because the borrower has an equitable interest. So what the bank is looking for is, one, for the outstanding amount of the loan to be paid off. And if there is anything left, it goes to the borrower. That would be his equitable interest in it.
Ms. Archer, I have a question in reference to the Homeowners Protection Act. What proof will be needed? Because we have the Homeowners Protection Act in place. And, you know, sometimes you still see some homes, you know, they would foreclose on. So what proof would the courts need to state that, or evidence that we would have complied with the Homeowners Protection Act in reference to finding other family members that may have been qualified to take it over?
Now, when you say evidence, what the bank should already have in place standard communication that they would actually send out to their clients or document probably in a meeting where asking the client if they have anyone else who can assist them with making the outstanding payments.
Okay, the reason why I asked this question is because you go through that process. But I've seen situations whereas by the time you get to court and let's say you're waiting on that final decision for the vacant possession, you know, or getting ready to proceed with sale, then, you know, the courts then make another decision. Let's say if they come up to say, well, oh, we found this money, or, oh, we have somebody who would be willing to do. But you would have gone through all of this long process. You now have somebody who's willing to purchase. And now you have to stop that sale because now, so I guess my question should be, is there a time frame? Or that's why I asked, which evidence can you provide so you can say, well, look here, we would have exhausted the time frame to deal with this client and also for them to come up with some form of means of paying. Now we want to proceed.
Oh, I would say, unless a matter, like how you described it, comes before the court and the court determines that the time period has been too long and sets a standard as to what is too long or what is the required length of time, then it's up in the air. Because remember, the act doesn't speak to a time period in it. So the only way that can be interpreted is if a matter, like what you're saying, goes before the court and the court said this is an inordinate delay, it's too much time, it should have been done in 30 days, it should have been done in 45 days, 3 months, 6 months. That's the only way. And then the banks would follow the case law.
Yeah, I think that's the loophole right there, because it's not specified with a time or like what you need to provide for the evidence. So I guess, I mean, I don't know if to say the court is lenient when it comes to that, but
yeah, but
normally
remember,
you'll find it goes in the favor of the homeowner.
Of course, it will go in the favor of the homeowner, because that's what the Homeowners Protection Act is all about. Remember, that's the purpose of the legislation. Now, the question, the thing is that when you go before the courts, your attorneys have to bring the point out as to what they're arguing. You're not just, yes, you're arguing that you want to sell to the person who came along. These people just come and make a decision and find someone. But the gist is, you have to trust before the judges that, was this delay reasonable? So that the court can then bring your cases before the court from other cases. Remember, the very first lecture was on sources of law. You will have to find cases in the Caribbean or in the Commonwealth that speak to reasonableness in a process like what we have in the Homeowners Protection Act. So the court can make a decision as to what is reasonable in terms of the turnaround time and finding someone to meet the borrower's obligations. You understand what I mean now?
Yes, I understand. Thank you very much.
Yeah. So it all comes to reasonableness and letting the court determine what is reasonable. And then, see, the thing about it is this, is that when you speak before the court, remember now, the judges are not a part of the financial institution. They only know what they see and hear when matters come before them. So this whole loop that you're saying, they would not be privy to that loop unless a matter has come before them before, and the lawyer would, in his presentation, was speaking about the issue with the loop. Now, another thing you can do as a financial institution is, if that is an issue, not a minor one, but an issue that it can be seen across the board with all financial institutions, then the head of each financial institution has the opportunity to bring that matter before their regulator and asking their regulator, legal department, to look at those provisions with a suggested recommendation from the financial institution that there is a gap here that needs to be closed, and take that matter to the Attorney General's office. Everything is a process. And they should be able to say, Attorney General's office, whether or not that was omitted intentionally, or whether or not it is a loophole and they have to close it.
Okay, great, thanks.
But it's just whether or not the powers that be at the very top of the institution, one, is willing, or two, understands what the issue is. And they could bring that matter up among their counterparts from the other institution to see if they're faced with the same problem. That could be just a call. Once they all agree that that is an issue, that we are faced with this piece of legislation in this section, then they move it on. All right, so everybody's okay now with the legal mortgage. and transferring the legal interest to the bank. Now you can also have an equitable mortgage. So an equitable mortgage is when you would confer your equitable interest to the bank. Now you would see this sometimes when you have beneficiaries of a trust. And we're going to talk about trust after this. But a beneficiary only has an equitable interest in the assets. And so they may be living in a house that is owned by the trust, but they have an equitable interest. And they can mortgage their equitable interest. Or you can have an equitable charge. But with an equitable charge, you have more limited rights than a mortgage. That's why banks prefer the mortgage. So a mortgage document, it just speaks about the parties to the transaction. Again, you have the terms and the condition between the bank and the borrower. After you've done all the title searches, you've checked your taxes, utilities and assessments, your subdivision approvals and all of that. Then the mortgage document is drawn up and it gives you the obligation of the mortgagor, which is the borrower, and the mortgagee, which is the bank. It tells you what the payments are. It tells you what you have to do, such as keeping the property properly insured, make sure it's being maintained, make sure you pay all of your taxes, and that you observe all of the restrictive covenants and the regulations, and you protect the title to the property. The mortgage will also have the description of the property itself. It'll tell you how long the mortgage is for, the amount of the monthly payments, the date when you should pay. It gives you the redemption upon repayment of the loan. What happens if there is a default? Because the bank itself in the mortgage document tells you what their remedies are when they exercise their right, when you've missed 3 consecutive payments. You get an opinion on title. An opinion on title, again, speaks to the validity of the title of the property, which means that it confirms that you have good and marketable title.
Ms. Archer, I like to listen to words. You said just now 3 consecutive payments. For the bank to move or act, I don't think it have to be consecutive, right? Because you could miss this month, pay next month, miss the month after that, then pay the next 2 months, but then miss the 3rd month, and you still end up with 3 months payment that you would have missed. They were not consecutive, but they were 3 months, so the bank can still act.
Let me look in. I already have another one. You have to go to the Law of Conveyancing Act. And also the mortgage deed. What is the mortgage deed? What does the clause say in the mortgage deed? What does it normally say? Does it say 3 payments or it says 3 consecutive payments?
I'll have to confirm, but I think it's just 3 payments.
It just says 3 payments? I'm trying to get onto the laws of the Bahamas. See if I can get there. No, that's the one for lease. I don't want lease. Let me see. Let me hold on.
I mean, indirectly, based on how some of these systems are set up, they would force it to be 3 consecutive payments, especially if, let's say, you miss a payment and you come back and you're making another payment, but unfortunately, it doesn't go towards the month that you want it because they're going to apply it to the month that was missed. So I guess indirectly, it still end up consecutive.
Yeah, I'm trying to find it in here. I can't remember the section out of my head, but let me see. I'm in the act itself. I'm just trying to remember the section 20. Because you should have a policy in place for when the borrower misses payments as to what to do. So when they miss the first payment, what do you do?
I mean, to answer your question, yes, there is a policy, but like I said, based on what you were saying, and I know you were quoting according to law, and because you use that word consecutive, and I know normally you wouldn't see that word consecutive, you would just see payments. Yeah, but there is a process as to when it's 30, 60, 90, and then beyond.
Okay, so it says, a mortgagee shall not exercise the power of sale conferred by this act unless and until notice requiring payment of the mortgage money has been served on the mortgagor or one of several mortgagors, and default has been made in payment of the mortgage money or of part thereof for 3 months after such service. Or some interest under the mortgage is in arrear and unpaid for 2 months after becoming due. Or there's been some breach of some provision. This is section 22 in the Conveyancing and Law of Property Act for when the bank can exercise the power of sale.
Yeah, so it doesn't say consecutive. Yeah.
No.
Okay.
Yeah. 3 months. But I know in some instances, I've seen where banks in their thing they have it as 3 consecutive. But you can change it. It says 3.
3 consecutive months would be good for a lot of people. At least it would buy them at least some more time. But I mean, like I say, if you miss one, then to try and pay 3, that's a challenge too.
Yeah. Yeah, unless you get a lump sum. Yeah, but it says for 3 months after such service. And then, of course, the bank will register it because it has to protect its interests. And mortgages rank in order of priority according to the date of recording of the mortgage document. So remember, I told you first in time. So when the mortgage has paid off the loan and the property becomes free of the mortgage granted over it, the mortgagor has what they say redeemed the property. So during the currency of the mortgage, the borrower has what we call equity of redemption. So that means that they have the right to redeem the property at any time once they've paid the principal and the interest and the cost of the mortgage. So the value of this equity of redemption is the value of the unencumbered interest minus the value of the mortgage loan. So at any point in time, a borrower can come and check and see what is their equity in their home and use that equity to borrow against the security that the bank holds. So the Homeowners Protection Act was legislated to provide the protection. And I think the courts once you qualify under the Homeowners Protection Act, if you were to dig deeper in the mortgages, and then you'll see how a lot of the borrowers try to stretch that time. Just like we were saying, they tried to stretch it in order not to move out of the home. And the courts normally rule in favor of the financial institution. Any other comments? So that's the mortgage. Now let's talk about a trust. Anyone familiar with a trust? No? Yes?
No.
No, not really.
No? Okay. Let me see if I could break it down as much as I can. All right. So you have persons who have assets, and they want to manage those assets for their family, or sometimes for themselves, or for them and their spouse, or just for their children. So what they do is they decide that they want to have a trust and have someone manage those assets for them. Now, to create a trust, the person who's offering that service has to be licensed by the central bank. So the legislation that covers trust business is the Trustee Act, the Trust Choice of Governing Law Act, the Fraudulent Disposition Act, the Rule Against Perpetuities, and the Abolition of Perpetuities. So what exactly is a trust? A trust is not a contract. That's the first thing. It's actually a legal arrangement where the person who owns the assets, and that person can be called a settlor, they could be called a donor, they could be called a grantor. They have the legal and equitable interest in those assets. So when they create a trust, they transfer the legal interest to the trustee. And that trustee holds, manages, and administers those assets for the benefit of the beneficiaries. The beneficiaries can be individuals, or the beneficiaries can be what we call a class of beneficiaries. That they could say all my cousins, all my grandchildren. So within the asset, within the trust, the assets can be money, could be jewelry, could be property, could be commercial assets. Whatever the assets are, the trustee has to manage those for the benefit of the beneficiaries. Now, the beneficiaries receive payments from the trust. And the beneficiaries themselves have rights to the trust. Once the settlor creates that trust by transferring that legal interest to the trustee, he no longer have rights over those assets unless he becomes a beneficiary himself. So as a beneficiary, You can receive income from the trust, or you can receive capital from the trust. So only the beneficiaries of a trust can enforce it, and they have rights by law. So if someone wants to create a trust, there are different types of trusts. Trust doesn't have the name on the top to say this is this type of trust. You know what type of trust it is when you read the provisions within the trust instrument. Most of the trusts here in the Bahamas are discretionary trust. Some could be spendthrift trusts. So a discretionary trust is where the trustee makes the decision as to who receives benefits under the trust. They also decide how much you will also receive under the trust. We have a trust can be a fixed income, non-discretionary trust, and that's where the settlor would have stated how much to give each beneficiary and when they should receive it. You could have a part discretionary, a part fixed trust, or your trust can be revocable or irrevocable. And you'll see a lot of trusts that are revocable, a trust that are more or less what we call business trusts. So why would someone want to establish a trust? They do it for different reasoning, but mostly it's for estate planning, because there are benefits in having a trust. One, you don't have to wait for probate, because probate takes a long time. Once you put it in the trust, if you are a beneficiary, your benefits continue. There's no break in between. Second, a trust is confidential. There's no public viewing of trust documents. Second is your assets are going to be managed by experts. So under the Trustee Act, it allows the trustee to employ agents to assist in carrying out his investment functions. The Trustee Act also allows the trustee to have indemnity insurance against acts that are done in a skillful and prudent manner. Also with a trust, there is no delay in receiving assets. And of course, under the Fraudulent Disposition Act, a trust is used to protect your assets from creditors. So a trust is no longer seen as an instrument just for wealthy people. You can use it for many different purposes. So normally you would speak to a trustee and you would state what your assets are and your purpose and your reasoning for wanting to establish a trust. So those who want to make financial provisions for their family or their friends during their lifetime or even after death, they would create a trust. Now, once a trust is created, it can be transferred to another jurisdiction, as long as the laws are comparable with the jurisdiction where the trust is coming from. So within the trust deed, it would have the provision for everything that the trustee is supposed to do. That means investments, transferring a trust, appointing new directors. It has provisions for a protector who would give advice to the trustee. All of those provisions are in there. So the trust itself will tell you what is the proper law of the trust. That's the law that will govern how the trust operates. And if that provision is not in the trust deed, then what the courts will look at is they look at where the trust or what the trust is closely connected to it. Either where it is administered, or they look at where the assets are, or they look at where the trustees reside, or they look at where the beneficiaries reside. So remember now, when it comes to trust, even though it's for estate planning, it's for financial provision, there's also taxation that needs to be considered. But normally it's advisable that the proper law of the trust is where the trustees are resident. So that there's protection for the trustee in the event there is a dispute. So in most trustees, there is a provision for you to change the proper law of the trust to another jurisdiction. So if you want to transfer trust from one jurisdiction to another, you would use the deed of retirement and appointment. And on retirement, the existing trustee and the appointment of the new trustees, the assets are transferred. And once the assets are transferred, they automatically vest in the new trustee. Sometimes, instead of going that way, what they will do is just revoke the existing trust and declare new trusts and give them new names. So the transfer of trust from one jurisdiction to another, there are some consideration. You look at the similarities and the differences in the trust law. You look at the interests of the beneficiaries, whether or not it be prejudicial to moving from one jurisdiction to another. You look at the way in which words are interpreted in that jurisdiction, and you make sure that the appointment of the trustee in the new proper law jurisdiction. And another provision you'll see in trust deed is the flee clause. And that means that if a country becomes unstable, that you want to be able to move the trust from one jurisdiction to another jurisdiction. So what makes a trust valid? A trust can be made while a person is living, or it can be made after a person's death. So after a person's death means that it is actually in the will. While they are living, that's when they sit in front of a trustee. Now, there are persons who create a will, or prior to creating a will, they actually say what they want, or they write it down. And in that instance, the court then has decided whether or not the will is actually valid. And to be valid, there are three things that have to be in place. The words must be certain. The subject matter must be certain. And the objects must be certain. So the words means that the person who is creating that trust have to use the language that gives the intention that they wanted to create a trust. Second, they have to know the assets that they own. And third, they have to know who they want to benefit from those assets. So if the certainty of words is not clear, then it becomes an outright gift. If the subject matter isn't clear, and remember the subject matter is the actual assets, then there is no trust. And if the objects, which is the beneficiaries of the trust, are not certain, then a resulting trust will occur. And that means it goes back to the settlor, or it goes to that person's estate. Any questions? Is it clear? Clear as mud? Clearer than mud?
Some of it is mud for me, but I just have a question. When it goes to the person's estate, what would be the process? Because the person didn't leave a will. If it goes to the estate, then what's the process?
Next class. Okay. Next class, we're going to do wills. But I can tell you now, in a short form.
That would be nice, because let's say there's no will.
So, under the laws in the Bahamas, when you die, you can die with a will or without a will. If you die without a will, then you follow the rules under the Inheritance Act. If you die with just a spouse, the spouse takes all. If you die with a spouse and one child, 50-50, spouse and children, 50-50, and it goes down the line. And we'll discuss that next week. Why you went quiet?
It's a little touchy for me because I think you know what I'm dealing with.
Yes. You had another question? Or you wait for next week?
Yeah, I'll wait for next week because you may disclose the answer that I need.
Oh, okay, okay. And then you wouldn't have to ask. Okay. Okay. All right. Or probably what you could do is write your questions down and then as we come across it, you'll see if they're being answered. And then depends on what it is. Then you could just go from there.
I could do that, but at the end of the class, if it's okay, I have a question that I would just want to ask you privately in reference to the property.
Oh, okay. Okay. Not a problem. All right. So investments, I leave that for when we do the next section. So we'll talk about the investment funds then. So what we're going to do now, before we finish for the days, we're going to look at doing business in the Bahamas. What other thing I wanted to discuss? I don't know if I should do this one now. I normally give an example of when we talk about property and mortgages and matrimonial property. Do you know how that works?
No,
I think it depends on whether it's joint tenants or tenants in common.
Yeah, that's if you're giving property, but I'm looking at when you're talking about property acquired before the marriage. I'm going to give you all a case and y'all could think about it. So these parties were married in August 2015 and their marriage was dissolved in 2017. They had no children. So they had a duplex in Venice Bay. It was purchased by the wife prior to the marriage with the assistance of a mortgage, and it was in her name alone. The husband moved into one of the units with the wife after the marriage, And so that unit became the matrimonial home. So now they're before the court of appeal. They're already been to the Supreme Court. And the husband is appealing the decision of the Supreme Court. So from his ruling giving the husband only 10%, the Supreme Court gave him 10%. The judge said it is a significant departure from the equal sharing of matrimonial assets. The judge clearly found that the husband's financial contribution, as a matter of fact, was less than that of the wife. He found that the husband hardly worked a real job. The judge granted him a 10% interest in the property based upon its value of $245,000. That does not take into account the fact that there was and still is an outstanding mortgage on the property. The evidence shows that in 2016, shortly after the breakdown of the marriage, the mortgage was in the amount of approximately $104,000. So the judge is saying the modern law is an equal sharing of assets, unless there is a reason to depart from that equal sharing principle. The overriding obligation is to be fair. Fairness does not always require an equal division of assets. He said the judge made a radical departure from equal sharing on the basis that the Venice Bay property ought not to be regarded as matrimonial asset, having been acquired before the marriage by the wife, and that the husband made little financial contribution. And the judge in the Court of Appeal is saying that that judge, in his decision, fell in error in his approach. He said both parties accepted that this was an appropriate case to depart from equality. The husband only sought a 40% interest. That's what he's asking. He had asked for in the Supreme Court. He asked for 40% of the value of the property of $245,000. The wife said she would give him 15%. And of course, the Supreme Court offered him 10%. So the judge is saying it is unclear how the trial judge came to determination that the husband's interest should be less than that which the wife herself proposed to be his interest. There is no explanation, and the 10% appears to be capricious and arbitrary rather than an exercise of judicial discretion. Moreover, it was based on the premise that it was not a matrimonial asset. For these reasons, this is a proper case for an appellate court to set aside a discretion exercised by a trial judge and fix the husband's interest at 20%. A 20% is more appropriate because, although a significant departure from the equal sharing principle in relation to matrimonial assets, it reflects the trial judge's finding that the husband, during the course of the marriage, did not contribute to the home as would have been expected in a marriage partnership. It is consistent with the principles set out in the case of Miller versus McFarland that a matrimonial home should be regarded as a matrimonial asset, even where it is brought into the marriage by one party, and the marriage is a short one. It is also a recognition of the unequal contributions made by the parties, and that the wife made more of a contribution to the acquisition of the asset. However, it would be wrong to give him a 20% interest in the property at a value of $245,000. His 20% interest must be based upon the net value of the home. That is to say, the appraised value of the home less the amount of the mortgage. That is $141,000. So his 20% interest must be $28,200. Any comments?
I'm going to be biased and I agree with that.
No, I agree with that.
Yes, I agree with that. Especially it's a short marriage, only from 2015 to 2017, I think you said.
I was still was 20% though.
They was going to give him 20%?
They gave him 20%, but 20% of the net.
Oh, yeah, I agree with that. I totally agree with that.
But that's the net less the after the mortgage came
Yeah.
up.
Yes, yes.
So that's good. I agree with that. 28,000 for 2 years. Even.
Yeah. But at the first judge told him he was getting 10% of the 245.
No.
But that's basically the same, just short of a few thousand.
Yeah, it's just that I think that the Supreme Court judge didn't rationalize how they were given this 10%. But I still think that's a lot of percentage for someone who only was in a marriage for 2 years. But the key thing I wanted you all to listen to is that the place was purchased by the wife prior to the marriage through a mortgage, and the mortgage remained in her name, and she moved him in, and he came out after 2 years with 20%. Just letting you know.
Wow. So in that case, Ms. Archer, I have a question. What should someone do prior to the marriage if they already have properties or assets in their name to protect, I guess, I don't know, their name? Even though they're getting married, what would you, that's where I think you want to talk about the wills and stuff next week.
But yeah, wills is upon death. Some people, some men, you see men do it, some women do it too. They would form a company prior to marriage, not 6 months.
Sorry?
I said not 6 months before, because then the court is going to question, what was your intent?
Ah, okay.
Yeah, you have to be very careful. So if you say you're going to be purchasing property, let's just say you decide to get married at what, say 40. But a lifetime you were saving and buying properties. It would be good if that's what you intend to do, is to form a company.
Okay, and put the assets in the company.
Yeah, so that if you do get married, he cannot say that you did that to take it away when it comes for the divorce time. And then you're careful, because there are cases where there is a case where a husband had the assets and his operating company together. The children were the shareholders along with him on the company. But when he married his second wife, he had asked her to help him to boost the company sales. Working with him on the company. But the court decided that he had other assets. So the court decided not to disturb that, seeing that that was something that was already in place, and his children were the shareholders on that company. They didn't want to disturb that. So what the court did was it took other properties that he owned and gave it to the wife.
So the other properties weren't in
no, they weren't.
IBC.
No.
Okay, gotcha. So you don't put all your assets in a company. You need to at least leave one out there, so just in case something does happen, you gotta find a way to strategize.
Yes, yes.
Okay.
Ms. Archer, another question in reference to all of this. I mean, wouldn't a simple solution be a prenup?
We don't have that here.
I'll come to that next week. I do have a case on prenups. Huh? Every class asks that. I don't know what's wrong with y'all. Your emails always coming. We'll talk about prenups when we talk about wills next week.
Okay.
Yes. That's always my segue into wills, is to talk about prenups. Yes.
Okay, Ms. Archer.
All right. So now before y'all go, let's talk about joint ventures and mergers and stuff in the Bahamas. Last week I asked you all if you all were familiar with the case with the what the people name again? The Greeks and fronting. You remember that?
Vaguely.
Yes, with the persons on Bay Street with the stores. When you pass, they keep pushing these little papers, little sachets, talking about cream for your face.
Oh, yeah, yeah.
Yes, that was a case where the court ruled that they were the Bahamian company was doing a fronting operation. So there are some areas that are exclusively for Bahamians. And in that instant, that was one of them. So when you want to do business in the Bahamas, you have to abide by the national investment policy formulated by the government. And as the government change, the policy, the framework for the policy remains the same. The areas reserved for Bahamians remains the same. It's how you go about it. So applications are made to the National Economic Council. And the Bahamas Investment Authority is responsible for all the operations. So wholesale and retail operations is exclusively for Bahamians. Import, export, Bahamians. Real estate and domestic property management, domestic newspaper publication, advertising, commercial fishing, security services, domestic distribution of building supplies, construction companies, except for the special ones. And we'll see how this works with they're moving along the Contractors Construction Act. So we'll see how that one works going forward. Personal cosmetic and beauty establishments, auto and appliance services, public transportation, and landscaping. Those are left for you all, domestic. Now for foreigners or person who want to invest, of course, the tourist resorts are for them. The upscale condominium and timeshare, second home development, information and data processing services, high-tech services, ship repair, offshore medical centers, agribusiness, food processing, mariculture, aircraft services, pharmaceutical manufacture. All of these things are for people who wish to invest in the Bahamas. So even though persons can come in as a foreigner, the government encourages joint ventures with Bahamians. Now, permanent resident doesn't qualify as a Bahamian partner. So in order to bring a proposal before the Bahamas Investment Authority, you have to give a proposal outline, an outline as to what you want to do, the location, the type of business you want to get into, who are the principals. You have to provide all of their IDs, when they intend to start up, how much Bahamians are they hiring, how many non-Bahamians are they hiring, the management structure, the financial planning. Also, you have to follow the environmental impact assessment, the legislation and the regulation. And of course, the minimum investment is $500,000. Normally, to engage in a joint venture, the company should be incorporated under the Companies Act. And there's normally an annual declaration that states the ownership of the company. So the majority of them are 60% owned by Bahamian and 40% by the investor. They also have to obtain exchange control approval. The operation would be designated resident for exchange control purposes. And of course, there can be restrictions on the borrowing for that company, dealing in foreign currency, and capital investment. So in order for the central bank to give approval, they normally request the prior approval of the National Economic Council before they grant any approval to a foreign ownership. If the Bahamian own less than 60%, then the annual fee is $1,000. And of course, the company has to obtain a business license. So normally this whole process of going before the National Economic Council is done via an attorney. Now, of course, when an investor coming in, there are incentives that the government offers. And once you qualify under any one of these legislation, there are, I guess, incentives for investors to operate a business in the Bahamas. So under the following acts, included exemptions from the payment of custom duties on building materials, equipment, and approved raw materials and real property taxes for periods up to 30 years. So normally, depending on the size of the project, you would see where the investors would first start out with a heads of agreement. And sometimes the heads of agreement is where they would start off first with these concessions or investment incentives first, and then they would negotiate on these. So you have the Hotel Encouragement Act, where they give you duty-free entry of approved construction material, fixtures, and furnishings. You have the Industries Encouragement Act, duty-free concession for importation of raw material and building supply for manufacturing. You have the Bahamas Vacation Plan and Time Sharing Act, duty-free concession for building supplies for a timeshare facility. You have the Free Trade Zone Act. That's the free trade zone area for industrial and commercial zone. You have the Hawksville Creek Agreement Act. That's the free trade zone of Freeport. You have the Tariff Act for agriculture and fisheries. You have the Export Manufacturing Industries for Spirits and Beer Manufacture Act. You have the City of Nassau Revitalization Act. That's the restoration for the City of Nassau downtown. And then you have the Family Island Encouragement Act, and that's duty concession for building materials on the Family Islands. So of course, you can have a merger between an IBC and a foreign company. And an IBC is a company that has been incorporated under the International Business Companies Act. And the law provides that you can take an IBC, which is normally incorporated by foreigners who want to do business using a flexible vehicle, and they can merge that with a foreign company that they've incorporated in another jurisdiction. So once the two companies are merged, and there's a surviving Bahamian IBC and a certificate of merger being issued, the merger is irreversible. So the principals of the merged company would notify the registrar of companies in the jurisdiction of the foreign company that it has merged with a Bahamian IBC, and of the merger of the two companies include the fact that the Bahamian IBC is now the surviving company. And they would submit the relevant documents to the registrar of companies evidencing the merger between the surviving IBC and the merged company. The beneficial owners of the merged company should be aware that the new company is different and is separate from either of the two companies that existed prior to the merger. So even though it may retain the name and it may retain the capital and even the employees, it is a separate entity. It's not the same as the two previous existing entities. The liabilities, the obligations, and the responsibilities of the merged company will separate from those of the two separate companies. And the contractual relationship of the third parties to the merged company will also be different and distinct from the previous two companies. The shareholders of the two merged companies should discuss and resolve any issues involving the continuity of the companies as a merged entity. And that would include looking at shareholding, contractual obligations, corporate structuring, any plans, any looking at the articles of association. All of those things have to be reviewed. Appropriate resolution of members should be prepared and executed to reflect the decision of the members to proceed with the merger of the Bahamian IBC and the foreign company into a surviving Bahamian IBC. Then you look at the effect of the merger on the corporate structure, the management, and the shareholding. And of course, the memorandum and articles of the Bahamian IBC has to be amended and restated to reflect the merger. Any questions? No? I think y'all will be excited next week when we talk about wills and prenups.
Yes, ma'am.
All right. So start your research on your paper. And what I'll do next week is just confirm that you've started your research. And for those who have gone further than the research, your approach, how you're going to approach the question. Okay?
No, Ms. Acha, where we starting from, London? What topic? Like what area, what angle? I ain't starting nothing.
No, that's what we were saying. We were saying at the beginning of class, start your research. Read the question, start your research, and then when we come next week, tell me how you intend to approach the question. I'll tell you if you're going right or wrong.
All right.
Yeah, that's what we're going to do. Everybody, I don't think no one said yet that they have started their research or started writing. So look at the question, start your research, and when we come next class, before we begin wills, I want you to tell me how you're going to approach the question.
Okay, will do.
Okay, all right. So have a great weekend. Go and watch The King.
Don't forget my question for you.
Yes, no, I didn't forget. I'll wait.
Okay, Ms. Acha. See you
okay.
next week.
Yes.
Okay. Have a good weekend.
Yes, you too.
Okay, thank you for waiting. I have two questions for you. One is more a personal one. My husband and I, we purchased a property from one of the family islands. This would have been some years ago. He was always saying that he was going to register the property, but I just realized now, because like I told you, he recently transitioned. So I just realized now that the property was not recorded. So I want to go about now to record it. And based on what you're saying, I don't even know what to do. Because, you know, I don't know if
Who's doing your legal work? You have a lawyer, right?
Well, what happened, we had purchased this from someone, and so there was some lawyer back then, but all we had to do, all they said was y'all just have to record it. All of the title search and all of that was already completed. But that part of it, that part of it was just never done. And so now I want to go and just pay for it to be recorded. A few years ago, I know we got it exempted from VAT. So we didn't have to pay any VAT, but what they told us is just go and pay the to have it registered.
Yeah, you should have done that. Now the thing is, a lawyer will still have to check to see whether or not that property hasn't been quieted. Have you visited the property? Anyone's on it?
Well, I don't think so. Like I say, this is on a family island. So we purchased this property. We never even looked at it. I can be honest with you.
So
So, I mean, if I go and register and pay for the registration now, I mean,
if no one else has registered it, then you'll be good. But if you get there and you register it and someone has already registered it, you're out.
Okay. So is there a way when I go to register it, can I find this out?
Let me ask my sister, because she's a real estate agent. I'll ask her.
Okay, I would greatly appreciate that.
So which island is it on?
This is Eleuthera.
Okay. Never visited. I just want to give her all the details.
Yeah, never visited.
Not registered.
No, we got the VAT, we got exempted from the VAT and all of that, but the only last thing was just to go and pay for it to be recorded.
Right.
Yeah.
Okay, I'll ask her.
Okay, greatly appreciate that. The second question I had, when I was reading through this document, it was stating that if a foreigner purchases a property, right? They are exempted from paying property tax. And I wanted to know if that is because of the high fee that they pay in order to be able to purchase land in the Bahamas. Why is it that they're exempted, but we have to pay the real property tax?
Remember now, that's all a part of having foreign direct investments. They have to have an incentive for foreigners to come here to purchase property, either to do business or as a second home.
Oh. Wow, so it's like an incentive, but boy, at the end of the day, we as Bahamians could end up paying much more than them.
Yes.
When it comes to the tax.
Yes. This is your home, so you're maintaining it.
Wow. Wow.
Yeah.
Okay, so yeah, so that was the two. So I guess once your sister, you have my cell. I don't know if you want to write it down.
Give it to me.
432 0826.
Okay, 432-0286.
No, 432-0826.
Oh. 0826. Okay, I'll ask her.
Okay.
Yeah, island now. She's coming in tomorrow, so I'll ask her and see what she says.
All right, then. I greatly appreciate it. Thank you so much.
Okay. All right.
I look forward to your guidance with this research paper.
No, that's okay. That's okay. I want you to look at it and see how you're going to approach it, and we'll talk about it next week.
Okay.
Yeah, not a problem.
Okay, will do.
All right.
Okay, so thank you. Have a wonderful weekend.
Yes, you too.